To our round discussion today, we are going to be reviewing two pieces of legislation that were passed this year, 2021, that have a significant impact on community associations. Ironically, that's all that passed. And they both have been signed by the governor now. These will go into effect on July 1, and we'll go through those. Give you a PowerPoint presentation as well. We will entertain questions as we go. As Jeff said, please use the chat icon at the bottom or the raise your hand icon under the Q&A part or whatever it might be. And we will be happy to answer your questions if you'll let us know. Jeff will unmute you and get you in. You can also enter the questions, like I said, in the chat room. As we're going through the first part of our presentation here, we would like to keep our questions relevant to this material. At the end, when we finish this material, as I do in all my discussions, we'll open this up to any questions you may have. We had some submitted prior to the class. I'm sorry, chat's disabled. Use your Q&A or raise the hand. Sorry about that. Thank you, Jeff. And I think I didn't see it down there, but we're happy to entertain other subjects after we finish our discussion as we move forward here. And I'm going to do this by using my PowerPoint presentation to share the bullets with you for the major changes that occurred this year. Main bill we're going to start with here is Senate Bill 630, which is now the legislation, statute number, law number 2021-99. And this bill made changes in primarily the Condominium Act, but also cooperative changes and HOA changes as well. But that's what we're going to look at here. Both of these bills will be available to you. If you have a request, we'll be happy to send those to you, email the PDF files to you as well. And we can also make, Jeff always makes a summary of our PowerPoint presentation available as well. But I'm going to start here with 630 and going through this sequentially as to what was changed. First of all, I address the Condominium Act. Basically, if a condominium's association insurance policy does not provide for rights for subrogation against the unit owners in the association, and the policy is issued to an individual unit owner, may not provide rights of subrogation against the condominium association as well. This will help prevent the rash of unfounded negligence clauses, claims against the association we've seen the last, at least one insurance company operating in Florida. Many, unfortunately, may result in increases premiums if subrogation against a couple of party is no longer possible. So that's a good change across the board. Can hopefully keep the insurance premiums to as low as possible. Another change was a change as far as the official records were concerned. Bids for work to be performed must be maintained for at least 1 year after receipt from the association. Previously, they had to be obtained from the inception of the association, but now it's just 1 year for bids. Also for condominiums, let's see. The renter would have a right to inspect and copy only the declaration of condominium and the association bylaws and rules. Previously, the renter was allowed to inspect and copy the bylaws and the rules, but we finally realized the declaration has a lot of impact on the renter as well, and they have the rights to know what the declaration provides as far as the use of the unit is concerned by the owner. And as we mentioned many times before, when the unit's rented, all of the rights of the use of the common property go to the tenant, and the owner can only use that property as a guest as well. Also, the statute was changed to provide that an association may not adopt rules requiring a member to demonstrate any purpose or state any reason for a record inspection. That's been a controversial issue for some time. That was already in the HOA statute. but they did add it to the condo statute now, so they don't have to have a reason stated to have access to the records of the association. And then for condominiums with 150 units or more, 150 or more units, the association, in lieu of posting copies of certain required documents to the website, may make those documents available through an application that can be downloaded on a mobile device. Those will be documents like the declaration, articles, bylaws, rules. All those are specified in 718. And a quick comment about websites again. Currently, the Condominium Act is the only act that addresses the website issue. It only applies to condominiums with 150 units or more. And there's specific provisions in the statute dictating what must be on the website. There is no such requirement for HOAs or for cooperatives yet. Probably will be in the not distant future, but right now it's condominiums only. Also, they amended the Condominium Act to pick up language that was contained in the Human Rights Law in Florida, Chapter 760, where it says condominium associations may extinguish a discriminatory restriction on governing documents. For example, provision which restricts ownership, occupancy, or use of real property on the basis of race, color, natural origin, religion, gender, or disability by board vote alone. That provision was added to Chapter 760, which is the anti-discrimination law in Florida. That's addressing the older condominiums were created back in the 60s and 70s, even to the 80s, where they did have restrictions on who could own and occupy units in the condominium. Most of that's been taken over, prevailed now by the Fair Housing Act, but it's kind of a blemish when people still see that in their documents. So the board can remove that from the documents by board vote, would not require an amendment to the documents or a membership vote to do that. Cleaned that up quite a bit for everybody as well. Also, one big question that was answered this year, we've been waiting for it. The Senate Bill 630 provides that term limits are intended to be prospective, with the service start date being on or after July 1, 2018. When that term limits was added to the law, was added originally in 2017, everybody presumed that it was prospective, but it wasn't clear. So they put it into the statute that it is prospective. So terms served before July 1, 2018 do not count towards the 8-year limit on service on the board. We also know that that 8-year limit can go beyond 8 years if a board member who has served 8 years is a candidate for the board and receives at least 2/3 of the votes cast in a valid election. They can take their seat back as well. The statute also increased the transfer fee stated in the Condominium Act from $100 to $150. And it's also adjusted every 5 years in accordance with the Consumer Price Index, raised accordingly to do that as well. And that's been something hanging out there for quite some time. We have all sorts of situations where condominiums have tried to circumvent that maximum transfer fee, calling it all sorts of things. But the bottom line is when a person buys or rents a unit, the association can only charge a maximum of $150 now in connection with the sale or transfer of that unit. And we can't have move-in fees or other fees or elevator fees or things like that as well. So that's the maximum transfer fee in the sale or transfer of a unit. Another change, which is probably good, if you have recall disputes, the parties to the dispute can now choose to go directly to the court with dispute or to arbitration. So we can circumvent the process there if we're so inclined. But that kind of just clears that up a little bit, makes it a little clear about how you can handle those disputes in arbitration or going directly to court. Also, we have a provision in the law 718 that prohibited the association to entering into a contract that was owned or operated by a board member or relatives of a board member having a financial interrelationship with the board member. That was totally prohibited, except where there was less than 1% ownership. And that was very limiting of what the board members can do. There was another provision added to the law last year that spelled out how to handle a potential conflict of interest between the association and a board member having a contract with the association to provide services or products to the association directly. That can now be allowed. There's certain bells and whistles you have to comply with as well, but the prohibition is no longer there. And that's the good change as well. And those two provisions were in conflict with each other for a year there, but that clears up the conflict also. They've also added language in the Condominium Act to accommodate natural gas fuel stations and providing that the people installing such stations must comply with all federal, state, and local laws. That also ties in with the electric vehicle charging station. All that is specified in the statute as well. The same provisions there for the electric vehicle charging station requirements imposed on the person desiring to install their own natural gas fuel station. It also says the board may make available, install, or operate an electric vehicle charging station or natural gas fuel station on the common elements or association property and establish the charges of the manner of payments by the unit owners, residents, or guests who use such stations. The station installation, repair, or maintenance will not constitute material alteration or substantial addition to the common area elements of the association property. That was a lot of associations, rather than addressing the electric vehicle charging station, or now the natural gas fuel station, as an individual installation within an owner's limited common area parking space. That could be burdensome and cause all sorts of issues. Now we can do a common area electrical vehicle charge station or natural gas fuel station, and doesn't require a vote of the membership. That was what was difficult before, because that would probably constitute a material alteration or substantial addition to the common property or association property. And that would, in most cases, require membership vote and approval. And if the documents are silent in a condominium about what vote is required for material alteration or substantial addition, it would require 75% of the owners to approve such alteration or addition to the common elements, which makes that difficult as well. Also, they provided that labor performed on or materials furnished for the installation of a natural gas fuel station or electrical vehicle charging station may not be a basis of filing a lien against the association. That goes back to the construction lien law. The association is not the owner of the property, so no construction liens can be filed against the association if the lien is filed against each of the owners, because the owners are the people that jointly. That removes that problem anyway. Construction lien can be charged where a contractor or supplier of materials or subcontractor has not been paid for their materials or services as well. If they are not in privity with the association or have a direct contract with the association, the contractor or supplier of materials must provide a notice to owner stating that they are out there, and that gives the association the obligation to make sure they get paid, or the person not in privity make sure they get paid. That clear. Also, the challenge to a plan of termination via arbitration or by mediation of the dispute, which had before just had to go straight to court. And the new law would allow the parties in a condominium dispute to now choose either pre-suit mediation, which has been used in HOA disputes, or arbitration through the Division of Condominiums, Timeshares, and Mobile Homes, or the division. And for election and recall disputes, mediation would not be an option. Such disputes must be arbitrated by the division or filed in court for election and recall disputes as well. Also, Senate Bill 630 addressed the emergency powers section of the statute and extended that emergency powers to include events like we've experienced for the past over a year, COVID-19 issue. It says the board can use emergency powers in response to damage or injury caused by or anticipated in connection with any occurrence or threat thereof, whether natural, technological, or man-made, in war or in peace, which results or may result in substantial injury or harm to the population, or substantial damage to or loss of property. That was expanded to include emergency caused by a contagion. Previously, the emergency powers section addressed only basically hurricane damage. However, the department, whether or not, stated last year when we had the first state of emergency proclaimed by Governor DeSantis, the department said that state of emergency also included the board's emergency powers, which allowed us to have adjustments in how we hold meetings, things like that as well. And we're all actually sitting here now waiting to see whether Governor DeSantis is going to extend the state of emergency one more time. Most of the people that I've talked to say it's 50-50 chance that we'll get another 60 days of a state of emergency, which does make it easier to comply with the meeting requirements and things like that. We'll talk a bit more about that later as well. And the board may exercise its emergency powers to conduct meetings, committee meetings, elections, and membership meetings in whole or in part by video, real-time video conferencing, or similar real-time electronic or video communication with notice given as is practicable. We got a question about that when we finish our discussions here, but that opens up everything we've been doing for the past year, and whether that was legal or not, it will be legal now July 1 in the future. And such notice for meetings can be given in any practicable manner, including publication, radio, U.S. mail, the internet, electronic transmission, public service announcements, and conspicuous posting on the condominium property or association property, or any other means the board deems reasonable under the circumstances. As I've said several times during the past year, people ask me, well, how far can we go? And I said, pretty much as far as you want to. Obviously, everybody, and try to get as close to the law. They expanded this. And
I want to interject a quick second. For those of you who are seeing Fred maybe freeze a little bit and some of the audio drops, I noticed it. Some of you might notice it too. We are battling some tech issues that faced us before we came on live to you today. So we'll keep it going as much as we can. And if it gets to the point where it's totally unbearable, we'll come back to you and we'll make other arrangements to do this one more time in the near future. So just we all want you to know that Fred and I want you to know that we are aware that there might be some intermittent stoppages due to the bandwidth issues that are being faced in Central Florida. Thank you.
Thank you, Jeff. And I forgot to mention that in the opening comments of one of my instructions I was supposed to give. I suffered an outage here, a jury rig right now. Got phone communication with me as best we can. And officials or public health officials are, upon the advice of licensed professionals retained by otherwise available to the board, determine any portion of the condominium property or association property unavailable for entry or occupancy by unit owners, family members, or tenants, guests, agents, or invitees to protect the health, safety, and welfare of such persons. That section does give the board the power to limit the use of the common areas. That was a big question during the state of emergency for the past year. How far can we go in keeping people away from gathering, and for example, in the clubhouse or using the pool or the tennis courts or the fitness center, so the board can do what's necessary and keep with all proper medical, legal, other advice and guidance as well. And the board can mitigate further damage, injury, or contagion, including taking action to contract for the removal of debris and to prevent or mitigate the spread of fungus or contagion. This section may be used to justify heightened sanitation protocols. And the board can even contract on behalf of any unit owner or owners for items or services which are necessary to prevent further injury, contagion, or damage, including without limitation, sanitizing the condominium property or association property as part of the board's emergency powers. And that clears all that. Also, another addition under the board's emergency powers in 718.1265, an association may not prohibit owners, tenants, guests, agents, or invitees of the unit owner from accessing the unit and common elements and limited common elements are pertinent thereto, for if such access is needed to facilitate the sale, lease, or other transfer of title to the unit. That provision was added to the law to address the real estate industry's complaints about the associations that totally shut down their facilities and would not allow other people to come in, anybody other than the owners or the owner's family. And even in some cases, prohibiting access by those folks as well. This clarifies you can't stop people from accessing the units that are involved in a transaction or transfer of title to the unit as well. And so I'm not sure whether we like that or not, but that does address the real estate industry's concerns about that as well. And they also clarified the fining process a little bit. It specifies that fines are due in 5 days after notice of the approved fine is provided to the unit owner and applicable to any tenant, licensee, or invitee of the unit owner. Previously, fines were due 5 days after the date of the fining committee meeting in which the fine was approved. That was not really clear because the meeting might be held. We still don't know, the owner doesn't know about it for several days after that. So the 5 days we start after the notice is provided to the unit owner. The fine has been approved, the 5 days to pay the fine. And that's still a problem. If the owner doesn't pay the fine, then that becomes a court issue for condos and cooperatives. And then we have to go to claims court to get a judgment to try to collect the fine that way. For condos and cooperatives, the fines are still not providing lien status. In the HOA world, fines of $1,000 or more do have lien status. Less than $1,000, they're not lienable, but that makes it a little bit easier to get performance of paying the fine. And multi-condominium associations may adopt consolidated or combined declaration of condominium, but cannot merge the condominiums or change the legal description of the condominium parcels unless accomplished in accordance with the law. That applies to associations existing on July 1, 2021, when this law goes into effect for consolidating or combining condominiums declarations as well. It also expands the division's jurisdiction to investigate complaints related to maintenance of association records. Previously, going back to 2008, the division's powers to investigate complaints after transition occurred were limited to complaints regarding financial matters, access to records, or elections and recalls. And that was the extent of their responsibility to investigate complaints and also resolve issues. Now they can investigate complaints related to maintenance of records. And the statute spells out how long the records must be maintained. There are 6 items that are permanent records. Other items are for 7 years. Election records are for 1 year. That's specified in the statute as well. So there's a little bit broader protection to the condominium owners and residents. The Cooperative Act 719 was also amended. They defined the unit to state that an interest in units is an interest in real property. Cooperative world has had this stepchild treatment for years. Technically, in a cooperative, the association owns all the real property. And the purchaser of a unit actually gets a share in the association. And that share represents a membership in the association and obligates the owner to pay their share of their operation of the association, maintain the common property through the assessments and based on the proprietary lease. We have done over the years tried to basically convert the condominium share to a deed. It's still not defined as a deed, but it now says that the unit is an interest in real property. That does give you the ability to transfer a little bit easier. Also, can be used as security for a debt. It's good for a good change for the cooperative world. They also put the same language in the Cooperative Act they put in the Condominium Act previously, we said, where the association may not require a member to demonstrate any purpose, state or purpose or state any reason or order to inspect the official records. As we said earlier, that's been in the HOA law for some time. It's now in the cooperative and condo law effective July 1, next week. They added the language to the Cooperative Act that was already in the condominium and the HOA statute where it says a board or committee member participating in a meeting via telephone, real-time video conferencing, or similar real-time electronic or video communication counts toward a quorum, and such member may vote as if physically present. That clears that provision up for board meetings, even though we haven't needed that because of the COVID issue, state of emergency in the past year, but it is there now as well. Also, they put the same language in the Cooperative Act where cooperative associations can extinguish a discriminatory restriction from their governing documents by board vote alone. And that's all spelled out in the condominium section that we talked about earlier. And again, that addresses those antiquated restrictions that are in a lot of the older cooperative documents as well, dealing with race, color, national origin, sex, handicap, religion, prohibitions for occupancy as well. Also, the same changes that we talked about just a moment ago for emergency powers are also set forth in Chapter 719 as far as the board's emergency powers are concerned as well. Very similar language, exactly the same language, as a matter of fact, just a little difference in the definitions. And then for homeowners associations, the definition of governing documents no longer includes the rules and regulations. There was a mistake made several years ago when they defined the governing documents in the HOA statute. Somebody stuck rules and regulations in there. It doesn't say board rules and regulations in the statute, it just says rules and regulations. But that was presumed to include board rules and regulations, which were now part of the documents. And that meant that when the rules and regulations were changed, they were part of the documents, they had to be approved by the membership, some legal interpretations. Also, there was basically an interpretation that they had to be recorded. And that meant they had to be voted on by the membership as well. So this clarifies that they are not in the governing documents and they're not subject to membership vote and also not subject to recording. Also for the HOA statute, they changed some language regarding notices of board meetings. It says, in addition to the authorized means of providing notice of a board meeting, the association may also adopt a rule for posting the meeting notice and agenda on the association website or an application, and must send an electronic notice, including the hyperlink to the website or application to members whose email addresses are included in the association's official records. That language is already in the condominium statute. They've expanded that now to the cooperative statute. And again, obviously that would only apply where the association has a website, and that is optional for the HOA world. One other change that was made here, the association must maintain for at least 1 year after the date of the election, vote or meeting, the ballots, sign-in sheets, voting proxies, and all of the other papers and electronic records related to the parcel owners. Voting, that's the same language we find in the condominium statute. Limits those records to be maintained for 1 year. And that was a good change. And ironically, that goes into effect July 1 also. I got a question earlier last week from one of our students for many, many years asking about that, where one of the owners in an HOA had requested the election records going back 7 years. And I said, well, I guess that does apply right now, but on July 1, that's going to change. So I don't know what they will wind up doing with that. But anyway, that's a good change, reduce the amount of volume of paperwork we have to maintain. Also, for HOAs, information obtained in a gated community in connection with guest visits to parcel owners or community residents are records not accessible to members or parcel owners. That was a privacy issue. There was some question about whether if you have a guest log or we have security footage of a guest entering, leaving the property, if that was an official record available to all the owners. So this makes it clear that that's not an official record. Doesn't say it's not an official record, just says that it's not available to other owners. Have to get some legal advice as to whether those are official records. Another change that was added to the HOA statute, where it said reserves won't be considered mandatory only if they're approved by a majority of the total voting interest, or the declaration articles and bylaws doesn't obligate the developer to create reserves. Previously, there was a provision that said if the developer had created reserves and they were in place effective October 1, 2008, the association must budget for those reserves thereafter. This removes that language and it says only if the declaration articles or bylaws obligates the developer to create reserves. And a little bit clearer language there as well. Also, it was added if the budget does not provide for reserve accounts under section 73066D, the declaration articles or bylaws do not obligate the developer to create reserves, and the association is responsible for the repair and maintenance of capital improvements that may result in special assessment reserves are not provided for or not fully funded. Each financial report for each preceding fiscal year must contain certain disclosure language and conspicuous type. And that disclosure language says if we don't have reserves, the board membership may vote to establish reserves as well. And the petitioner recall dispute now may choose to go directly to court or pursue arbitration with division. That was prior law said if you had a recall or election dispute in an HOA, you must go to arbitration provided by the DBPR. Because of the cost involved in DBPR's reluctance to do that, you can now bypass the department and go straight to court with that issue as well. Also for HOAs, Senate Bill 630, 2021-99 specifies that fines are due 5 days after notice of the approved fines provided to the parcel owner and applicable to any tenant, licensee, or invitee of the parcel owner. And it requires the requirement that notices required by 72306 statutes be sent to the address on the property appraiser's website, and notices only have to be sent to the mailing addresses found in the official records of the association. A couple of years ago, 3 years ago, maybe 4 years ago now, I don't remember when, they made a change in the law statute that said all the notices had to go to the property address as maintained on the property appraiser's website. That required HOAs to verify the address from the property appraiser's office, which may be different from the address the owners provided to the association. A great deal of extra paperwork and verification there. This makes it clear that we just send it to the address on record with the association as well. A good change for the HOA world. And one critical change they made in 2021-99 is the grandfathering of rental rights. It's been in the Condominium Act since 2003. And it says basically any governing documents or amendments that prohibit or regulate rental agreements apply only to owners who acquire title to the parcel after the effective date of the governing document or amendment, or to the parcel owner or who consents individually through a representative to the governing document or amendment. Existing owners who vote no or don't vote on the rental restriction will not be covered by the same. And this restriction does not apply to amendments that are governing documents which seek to prohibit or regulate rentals for terms of less than 6 months, or to limit parcel rentals no more than 3 times per year. And the grandfathering of rental rights does not apply to associations with 15 or fewer parcels. This is a provision, as I said, that's been in the Condominium Act since 2003, which basically said if you amended your documents to restrict rentals, it only applied to those who voted for the amendment and all subsequent owners. So as it says in this language, if an owner does not vote for the amendment or votes no on the amendment, such restrictions do not apply to that owner. And that impacts obviously short-term rentals. It also now has an impact on the Airbnb or vacation rentals by owner situation. Doesn't clarify that. And real quickly, there was a bill introduced this year to provide more direct regulation of that activity. The bill did not pass. It had serious opposition from various segments of society, so they couldn't come to an agreement on what to do about that. But this does limit the ability of an HOA to restrict rentals for those who are opposed to those restrictions as well. So consult with your attorney if you have any issues with that or are thinking about trying to restrict rentals in your HOA. And for definitions here, for purpose of determining the applicability of the rental agreement amendment, our rental restriction and change in ownership does not occur when a parcel owner conveys the parcel to an affiliated entity, when beneficial ownership of the parcel does not change, or when an heir becomes the parcel owner. That would be, for example, when the owner transfers the ownership to, for example, a corporation or an LLC, which the owner controls or owns the corporation or the LLC. So that would not be a transfer, and that would not also impose the rental restrictions that had been passed previously. So that protects the people who want to shelters and properties in there as well. Also, the HOA law is amended to provide that a petition or recall or election or recall dispute has the option for arbitration, or they can file in court. Previously, they were not eligible for precinct mediation. Election and recall disputes were subject to arbitration provided by the department only. So that language opens that up for other avenues of resolving disputes as well. And the bill also clarifies that turnover of control in an HOA will be triggered 3 months after 90% of the parcels in all phases of the community that will be operated by the homeowner association to be conveyed to members other than the developer. And that language is similar to what's in the Condominium Act as well, and cooperative. And this provides the HOA boards with the power to also extinguish a discriminatory restriction in their governing documents by board vote alone. And discriminatory restrictions were defined earlier. Again, trying to clean up the antiquated old language, which is basically addressed by the Fair Housing Act and removes those restrictions anyway. But get that out of the statute, so it cleans that out, get that out of documents rather, so it cleans that all up. It's not kind of ugly in there as well for some of those old language. And I believe that's the extent of 2021-99. Now we're going to look at one we've got several questions about. Chapter 221, 2021-91. Okay. Did I go away?
No, continue. Sorry about that.
No problem.
And there's a few questions from the first part in the Q&A if you want to take a quick look.
Okay. Oops. Jackie Grant, if you have to charge a transfer fee, can't charge a moving fee. The answer is you charge a transfer fee if it's provided in your documents, not more than $150. And my understanding is that's it. Move-in fees are not legal. So that provision, I know a lot of people would do that, but check with your attorney because that's a big issue. Move-in fees and the intent for condominiums to limit that transfer fee to a maximum of $150. And again, it must be in the documents as well. Jonathan Peterson asked a question, if you have a natural gas electric station, does the owner still have to go through the ARC rather approval process? I think that's perfunctory. If they complete the, if they follow the process as spelled out in 718 for the installation of the electrical vehicles charging station or the now natural gas fuel station, the ARC's approval would be automatic. It wouldn't be any questions or anything as long as they complied with all those. I think you could say it does require ARC approval. They'd have to have significant grounds to deny it. Question about the fine. Basically, the way that I recommend a fine is handled. If you have an issue where you're going to impose a fine, you first give a notice of violation and an opportunity to correct the problem. If the owner doesn't correct the problem, then the board would have to give a notice of fine that we're going to impose a fine of whatever the amount's going to be, and provide the owner with 14 days to request a hearing at that point in time. If the owner requests a hearing, there has to be a fining committee. Then the board and the owner opposing the fine will make their presentation to the committee. The committee then votes yes or no. Committee can't change it. They can't ask any questions. It's just a yes or a no. And then it says if approved by the committee, violator is notified of the fine, given 14 days to appeal. I think that's the process. I think you give the 14 days to request a hearing. Then if they request a hearing, you must give the hearing with a 48-hour notice. A question earlier was if the fining committee meetings are considered committee meetings, are they open to all the other owners? Yes, not necessarily employees of the association. Got a question about it says the service contract that was restricted, does that apply to a management company as well with a board member? First of all, contracting, and now the provision regarding conflict of interest in contracts only applies to condominiums, not to HOAs. There is no similar language in the HOA. However, there is language in the Not-for-Profit Corporate Act regarding conflicts of interest between the board and board members. And that's 617-0832. As long as the contract meets those requirements, then it's not considered improper. So whoever draws up the contract should comply with 617-0832 in the HOA world. Again, that restriction only applies to for condominiums.
Fred, let's continue with the program, and then anybody who wants to stay for the questions afterwards can stay, and you'll answer them all. This way, those who are here for the program can get the entire program, and if they want to sign off, they can.
Okay, we'll do that. Go back to my screen here. Give me a second. The other bill that I want to talk about pretty briefly, there's not much to it, is 2021-91. This bill basically says now the association has an additional notice we must provide to a delinquent owner before the matter can be turned over to the attorney. We have a time for notice to be sent by the attorney for condominiums cooperatives, 45 days. Both the notice of intent to lien and the notice of intent to foreclose. For condominiums, co-ops was increased to 45 days. That's the same language that was in the HOA statute previously. So effective July 1, if you're going to give a lien, record a lien, you have to give 45 days notice of intent to lien. Then before you can foreclose the property, you have to give 45 days notice of intent to foreclose. The second notice that was added is a 30-day notice or by the association before they may refer a matter to the association attorney for collection and recover attorney's fees and cost involved. The written notice is required to be mailed by first-class mail to the address of the owner on file with the association. If the address on file is not the unit or parcel address, a copy must be sent there as well. And the association is also required to keep in the records a sworn affidavit attesting to the mailing. And the statute has the form for that notice, and it's provided in the language of the statute, and that's an amendment back to 719-108 and 723-085. That's the section for each of the statutes as well. And that notice that we're going to delinquency notice, final notice of delinquency, whatever we want to call it, the language is in the statute. We can make that available to you after the program as well. This does place an additional burden on the owner as well, on the association as well. Also, the new language says, if the association wants to change the method of delivery of an invoice, a written notice must be delivered to the owner not less than 30 days before the change of delivery notice will be implemented. That would be for changing the delivery of an invoice, like the address or an email address, or changing the notice from a management company to another management company. Anytime we change the method of delivery of an invoice, you have to give 30 days notice. And that notice must be sent by first-class mail to the address on file with the association. If the address on file is not the unit or parcel address, a copy must be sent there as well. In addition to the notice requirement, the owner must affirmatively acknowledge his or her understanding of the new delivery method. And the written acknowledgement can be sent electronically or by mail. It must be maintained in the official records, although it's not available for inspection by other owners. And without this acknowledgement, the association may not change the method of delivery. One shortcoming here, the statute does not include a time frame for the owner to provide that acknowledgement or offer any remedy to the association if none is forthcoming. So that makes that a little bit as well. So that, again, is one more step for those of you that may not have delinquency problems. It's not an issue. For those of you that do have that problem, those issues, make sure you're complying with that. Get a copy of the statute and make sure that you have the proper process in place to provide that 30-day notice of final notice of delinquency before turning that over to the attorney for their processing. Also, depending on how you work with your attorney, the attorney may provide the notice of intent to lien. Some associations do that. That can be done by a licensee as well, but that's another burden in the collection process. And that's my review. I'm going to go back down to questions that we may have on the screen, or any that you may have also as well. And questions. We've got a question about a refundable damage deposits for move-in from Mr. Wells. That is not clear in the statute either. I think if you have a damage waiver in your documents, if you have some language in your documents that says the association, an owner is responsible for any damage they may cause to common property, you can require them to put up a deposit in the event they do property damage and the move-in. But you can check with your attorney on that. Again, that could be considered a transfer fee, and that again is limited to $150 maximum. Adriana says we have a $105 transfer fee in an HOA. That's an HOA issue. The HOA statute does not address transfer fees, so you need to check your documents to see if that fee is authorized in your documents. Question from Richard about HOA has established reserves. See if I can get that. Can they continue? Well, first of all, let me explain about reserves. Under the current language, the HOA it's going to be July 1. It says an HOA is considered to have reserves if the membership has voted to establish reserves by majority vote of the members, or if the documents of the community require the developer to establish reserves and they've done so. But previously, there's another scenario out there where we have HOAs which did not have reserves. It was not voted on by the members, and somewhere in the history of the HOA, usually after they had special assessment one time, the HOA board established a reserve program without membership vote or developer input. In that situation, those situations can continue, but technically those monies are not reserves. And since they're not reserves, as voted on by the members or established by the developer, they're not subject to the restrictions on use as that the statute says reserves can only be used for the purpose collected. So you would need to examine how those reserves were established in your situation, and also as to whether those restrictions on use would apply to as well. Okay, and that's not clear either. We can make the PowerPoint available to those that request it. I think we can do that, Jeff. If I'm wrong, let me know, but I think so.
Yeah, we'll have it go out as a link in the follow-up email.
Okay, thank you. Jackie says that the fine is due 5 days after the hearing. When does the initial fine continue? When does the continuing fine start? When you say each day of continuing fine, well, the fine is only for 1 day, for one event, one violation, and once you've opposed the fine, then that is the fine for that violation. And if you're going to say now they're in violation because they didn't pay the fine, then that you're going to say it starts over again. I'm going to question that. You want to get that process blessed by your association attorney, because there's only been one violation so far, and perhaps a non-payment of a fine might not be considered a violation as well. Had a question from Mr. Crooker about extinguishing discriminatory restrictions by board vote. Does that also apply to age discrimination? I'm not sure what you mean by age discrimination, but try to interpret that. And that is, if you live in an age-restricted community, then that is a part of the documents. And that is not discrimination as long as you comply with the provisions of the Fair Housing Act regarding housing for older persons. And that would not be a provision that would be extinguished. In other cases, if you have age restrictions which are not designed to comply with the Fair Housing Act, establishing housing for older persons, those could be removed by board vote as well, as I understand it. And again, the PowerPoint presentation as well. I think that's everything from that.
Yeah, for anybody listening, we're going to send out a follow-up email to everybody who attended tomorrow. And in that follow-up email, there will be a link where you can all click on the link and download and save the slides if you choose to. Fred, I received a question via email. Can you explain how can people get the Gray's Compendium? Because some folks are new to you and to Gray Area and to Gray Systems, and some new managers on board today as well. Thanks for joining us, by the way. What's the Gray's Compendium? How can they get it? What is it? And how can they contact you?
Gray's Compendium is a big book. Sitting behind me on the shelf up here. It's a compilation of all of the laws that affect community associations. It's over 1,000 pages long. It is available on our website for purchase. It's a subscription. We keep it updated every year. We put the changes in the from each legislative session, as long as you pay the annual subscription, which I think is $79 for the compendium. I can't remember, $79 or $89 a year after the initial purchase. We also have a second volume with that, which contains all of the Florida Administrative Code, which is all part of the package as well. That's available to you. It's also available on electronic version where it's a PDF file. You can carry it around with you, even on your phone or your device, whatever it might be. It is searchable. You can search for terms and phrases in there as well. It's a great research tool. A companion to that is the handbook, which is the how-to book, basically. That spells out how you do everything. It's also linked back to all the laws that are impacted by that statute as well.
It's great tools, and it's funny how life sometimes brings you full circle, because I back in my previous life when I was a manager over at Winmore, never heard of Fred or Gray Systems, and over at Winmore, when we got licensed, the company, they had us do all of our licensing and education with Fred. And then almost 20 years later, here we are doing some work together. So yeah, it's a great tool. It's a great item to share with your board. And it'll help you, it'll teach you a lot, and also a great item to go back and refer to, especially when you are holding your monthly meetings and such.
Also, I'd like to say, Jeff, we're not offering legal advice in that regard. This is for you, for your guidance as well. But quite often, when you say something, if you can show somebody something in black and white, it makes it a little more acceptable than just you're saying it. And I've always been a believer in that as well. And I'm saying, I'm not giving you legal advice, but here's what the statute says.
Yeah.
Here's what the administrative code says. And I think if you want further interpretation, we need to talk to the association attorney.
Fred, take a look at the question at 1056. When will the book be updated with 2021 statutes?
Probably in July.
After the July 1.
Yeah, after the July 1 date. The office is putting together the update right now. There are other laws that haven't been signed by the governor yet that affect some of the other statutes that we have in our book. I don't like to send anything out until everything's confirmed by the governor, signed by the governor. I got caught a number of years ago. There was a big issue that changed, and I want everybody to be aware of it. And this was back when Charlie Crist was governor, a long time ago. But anyway, I was broadcasting it out to all of our clients, and I put a big memo out and tell everybody about it. And 2 days later, he vetoed the bill. So I don't promote anything now until I'm pretty sure it's going to go through, or not going to be.
Yeah, there's the title of the new compendium. Don't count your chickens until they're hatched.
Yeah, that's right. There's a question about a violation in our ARC, like of a height of a fence. Board votes to
Hang on, you're fading in and out.
A recurring fine daily up to $1,000 for non-payment. Okay.
Yeah, let me read the question. Maybe your internet will stabilize by the time I finish reading the question. If the violation is an ARC event like height of a fence and the board votes to fine the owner $100, does it become a recurring fine, in parentheses, this person has daily, up to $1,000 for non-payment and non-compliance with the height restriction?
Okay. The fine is imposed, yes. The initial fine could be $100 per violation, and you could also state in the fine it continues for each day of continuing violation, but no more than 10 days, maximum $1,000. So that would, yes, that's exactly what would happen.
Okay. Were these other questions addressed? We'll do these 4. So, because we know we're at the time limit now, so we'll do these last 4. Unless you answered them already and I was asleep at the wheel.
Okay. Which one for those?
We have Richard at 1040. If an AHOA established, if an HOA has established reserves and are funding, may they continue or not to get membership vote?
I got that one. Rental agreements, I got that. I did not answer Judy's question. If there is not an appeal to the fine, does the committee need to approve the fine the board imposed? There's no committee meeting unless the person sought to be fined requests the hearing. Okay, and they have 14 days to request that. Okay, that's basically the process as been explained to me, as I've interpreted as well.
Excellent job as usual, Fred. Thanks so much. And we want to thank everybody for putting up with our tech issues this morning. On, Zoom is fantastic and technology is great when it works. And I can't smile too well with my dental surgery. That's why. But just to recap, you'll get an email tomorrow at around 10 a.m. Eastern with a link to download the slides, as well as a link to the compendium, as a couple of you asked for. So I'll put that link in there as well. Fred, one last time, I'm going to turn the floor over to you to sign off to everybody. Please let everybody know how they can reach you, and then you can sign off for us.
First of all, to thank Jeff again for helping us today and his condition, but he'll have him back strong shortly. As always, I want to say thank you for participating with us. We are available to you. Our website, gracesystems.com. We have a generic email address there, gs@gracesystems.com. My email is fcurry@gracesystems.com. I'm available to any of you with questions or concerns. We certainly appreciate your spending your time with us today. Post the recordings of the roundtable on the website under the resource section. We have some blog posts on there as well. Our newsletters are also added up there as we get those out. But anyway, there's a wealth of information there. Take advantage of it. Utilize it as well. We hope that you'll use this for your continuing education. We're happy to provide this, and we're going to continue our roundtable discussions on at least a monthly basis. And we'll be announcing the next topic for July shortly here. So with that, if there are no questions or comments, I'm going to say goodbye. Have a great day. Enjoy your lunch. And real updates tomorrow, the required one as well. And thank you again.